Excellent. Well, we'll go ahead and get started as the attendee room looks like it's filling up here. Again, welcome. Thank you for taking time out of your Tuesday to join us today. We're pleased to welcome you to today's webinar about a very important topic and a part of our work as comprehensive financial planners, and that is estate planning for you and your family. For those of you who may not know me, my name is Daniel Westergaard. I serve as our Chief Investment Officer and an advisor here alongside Jack and Tim at O'Connor Financial Group. Jack and I have the pleasure today of welcoming Lauren Kaplan, who is an estate planning attorney based in Chicago. Her specialty is in family law. So Lauren, I'll let you go ahead and introduce yourself to everyone.
Thanks, Daniel. Hi, my name is Lauren Kaplan, as Daniel said, and I am an estate planning attorney at Kaplan Estate Law LLC. And I work with individuals and families looking for peace of mind. And together we come up with comprehensive plans to keep your loved ones out of court and out of conflict if you become incapacitated or when you pass away. So thank you to everyone who came today. I'll take it back to Daniel and Jack.
Awesome. Well, just want to recap really quickly why we're here today and what we're trying to accomplish. For those of you who don't know me, my name is Jack O'Connor. I'm the head of our financial planning team here at O'Connor Financial Group and an advisor. And I'm going to forward one slide here on the screen here to show what the goal is of our time. It's to provide education with actionable advice so that you can, one, continue getting your financial house in order, and two, hopefully move you closer and closer towards a place of financial contentment, whatever that means to you and your family. So with capping that, I'll toss it to Daniel to start with our first panel question for Lauren.
Yeah, so the format for today's webinar will really be Jack and I asking Lauren a series of questions. And then, as Jack mentioned at the beginning, you do have the ability to join in either via the chat or the Q&A function to input your own question. And then Jack and I can read those off at the end of our organized questions. So the first question I have for you, kind of a softball, Lauren, what is an estate and does everyone have an estate?
Yeah. Great question. A lot of the times when I talk about estate planning with people, they start by saying, what is an estate? Or I don't have enough to have an estate. And the fact is that everyone does have an estate because an estate is just everything that you own. This is your home, your personal property, your bank accounts, your investment accounts, your retirement accounts, life insurance policies, business interests, or anything that you own legal title to. And it's really anything that you own at the time of your death.
Awesome, Lauren. So a lot of times I think there can be a lot of misnomers around this concept of estate planning. And some people think that, oh, that's just for people with taxable estates. So could you both define what a taxable estate is? And then more broadly, what's just a basic definition of estate planning in general? What does that mean?
Yeah, so a taxable estate is an estate that is above the estate tax exemption, whether on a state level or a federal level. So in Illinois, our estate tax exemption is $4 million. So that means that if you pass away and you have an estate over $4 million, then the government is going to take a tax on your entire estate. On a federal level, currently in 2023, the estate tax exemption is $12.92 million. So that means that if your estate is over $12.92 million, the federal government is going to take a tax on anything above that $12.92 million at a rate of 40%. And that estate tax exemption is subject to change. It's changing again in 2026. And so I like to tell my clients when we're doing planning, no matter how much time I spend with you, I'll never know three things. And that's when you'll die, what you'll own when you die, and what the estate tax exemption will be when you die. And so we really like to build in flexibility to all of our plans to make sure to provide a little bit for that estate tax exemption to try to reduce or even eliminate it entirely. And then second part of your question, basic definition of estate planning. So estate planning is really the process of organizing your assets, your property, and your finances to ensure that your wishes are carried out after your death or if you become incapacitated. And this includes naming a representative who will be in charge of your assets after your death or if you become incapacitated, naming beneficiaries or the people who will receive your assets. And then if you have minor children, it's naming legal guardians to take care of your children if you're no longer around.
Yeah, so a lot of times we'll bring up the concept of estate planning with clients, and sometimes people will respond with, "Oh, well, I have beneficiary designations on my 401k, my IRA, so I know where my assets are going. I'm all set." Can you talk a little bit about how that's maybe an incomplete view of estate planning?
Yeah, so naming beneficiaries is one part of estate planning, but it's rarely enough for people. So for one, if you have minor children or if you're leaving assets to minor children or minor grandchildren, they can't accept assets. So anything that you leave to a minor will be held up in guardianship court until the child turns 18, at which point those assets will be given to the child outright. But also, if your goal is to provide equal distribution to your kids, naming beneficiaries generally won't accomplish that goal. So just to give a quick example, let's say you have 3 kids and you have 3 main assets. You have your house, your bank accounts, and your investment or retirement accounts. So naming beneficiaries, let's say everything's worth about $100,000. The house is likely not in Chicago. But let's say you sell the house during your lifetime. The bank account stays at about $100,000, but with the investment account, you've been working with Jack and Daniel, and it increases to about $300,000. So one kid, the kid who is given the house, is getting nothing. One kid is getting $100,000 from the bank account, which stayed about the same. But then the third kid is getting $300,000 from the investment and retirement account. So naming beneficiaries alone generally is not enough to accomplish your goals.
Definitely.
Excellent. So if naming beneficiaries isn't complete estate planning, can you walk us through when you prepare an estate planning session for somebody, what are the documents that are included in that planning session?
Yeah, that's a good question. And, I really tailor each plan to the specific client. Not every client is going to need the same documents, but I would say for most of my clients who are typically, young families or parents of children, um, the plan generally looks like a revocable living trust, a pour over will, and power of attorney documents, as well as a living will and maybe some other healthcare directives.
So you mentioned the word revocable living trust. Can you give us a little bit more background on what a trust is generally and maybe some of the benefits of using a trust as a tool?
Yeah, so a trust is really just an agreement. It's an agreement between yourself as the grantor and the trustee who holds legal title to your property. And within the trust, you provide instructions for how you want your trustee to handle your assets if you become incapacitated and when you pass away. And it also provides for who you want to leave your assets to when you pass away, which is the beneficiaries. So there are a lot of benefits to having a trust. One of the main ones that I hear from clients when they come to me looking to put together a trust is that it avoids probate court. A lot of people put together trusts because they don't want their assets going through the court process, and they don't want their assets, held up by court after they pass away for what could be, 12 to 15 months or so.
That's
Definitely.
really helpful.
Go ahead, Daniel.
No, go ahead.
Just a follow-up question on that. So I know there's some individuals on this call who maybe completed documents years ago when their kids were young. Maybe they've updated them more recently as kids are in college or out of the house. But can you talk about a little bit about some of the triggers of different life stages that people come to where it does make sense to update documents when maybe you had them done in the past, which is great, but life circumstances change and there couldn't be reasons to update them?
Yeah, absolutely. So the triggers that I typically recommend for, drafting your first or updating your estate plan are getting married, getting divorced, having a baby, buying a house, starting a business, receiving an inheritance, or when you're thinking about retirement and you want to make sure that all of your assets are protected and passing in the right way.
Definitely. Is there another kind of life stage that sometimes can lead to different dynamics in families is grandkids arriving? Is there ever any triggers from an estate plan perspective where it does make sense to update documents as maybe some of your kids have kids of their own versus some kids do not?
Yeah, absolutely. So when I work with parents of minor children, for example, a lot of times we put together these trusts that keep the assets in trust for their minor child until the kid is 30 or 35. And a lot of times I'm working with people who have 2-year-olds or 4-year-olds. So we don't really know how well they are going to manage money. We just do that to protect them. So I generally recommend when your children do become adults, you revisit that estate plan to make sure that it still makes sense to pass the assets to the children in that way. And then another thing, like you said, when people have grandchildren, if you want to make sure your grandchildren are covered in your estate plan, if you want to leave anything specifically to your grandchildren, then you're also going to want to revisit that estate plan. And, I'm not going to go into this too much because it's a little complicated, but there's the generation skipping tax. So you want to make sure that if you're leaving a significant amount of assets to grandchildren, or, you skip a generation, you want to make sure that your estate is not going to be taxed on that. So it's really important to work with somebody who can protect you in that way and make sure that there are no additional taxes.
Awesome. So we've touched a lot on what happens with estate planning after someone's passing. Can you talk about some of the importance of having these documents in place while you're still living? Maybe examples of powers of attorney, and as clients age, why that becomes more and more important for them?
Yeah. So the number one thing is incapacity. I always recommend doing power of attorney documents, whether it's for an 18-year-old or a 60-year-old, because those protect you if you become incapacitated and can't make decisions for yourself. So the two POAs, or power of attorney documents, are the power of attorney for healthcare and the power of attorney for property or finance. And these allow people to make healthcare and financial decisions on your behalf if you can't make these decisions for yourself. And what they also do is they keep you out of court. If you don't have these documents and you do become incapacitated, and somebody needs to make decisions for you, the court is going to have to appoint a legal guardian. And then for the financial matters, everything gets pulled into court. There's yearly requirements to file accountings. It just gets pretty complicated and expensive when you can really do this very simple document to keep everything outside of court.
Jack, from our end, what are some of the difficulties if someone doesn't have financial power of attorney in place?
It can really, especially when it's a couple and one of the spouses is incapacitated, but the other spouse isn't. Sometimes assets can be locked up, which I'm sure Lauren can expound upon a little bit more. That just makes the situation a little bit difficult for specifically the other spouse or the rest of the family trying to either pay for care or just keep things moving forward in their situation. So anything else to comment on in that general circumstance, Lauren?
Yeah, I mean, it pretty much what you said. It does make things really hard for your loved ones if they can't access your assets to be able to pay for your care. If things get pulled into court, it takes so long, and the judge needs to approve everything. Even if it's your spouse and you're trying to move them into a facility, into a nursing home or long-term care facility, it could take months just to get the judge's approval to do that. So POAs are so simple to do and very inexpensive, and it's just an easy way to keep your assets out of court and make things just as easy as possible for your loved ones.
Definitely. So to jump over to a slightly different example of the court process being slow, you mentioned the term probate earlier. Can you define what probate is, how we can avoid it, and just general commentary around that process as well?
Yeah, so probate is the court process through which your assets are distributed and identified, and taxes are paid and creditors are paid if you pass away with assets in your name. So a lot of people seek to avoid probate because, like I mentioned earlier, it's expensive, it's very time consuming, especially in Cook County. There's a ton of administrative work to do, and it puts a large burden on your loved ones during what already is a very difficult time. So a lot of people do start estate planning, like I mentioned earlier, because they want to avoid probate and they have that number one goal in mind.
So can you give some examples of assets, if they weren't properly titled or the proper planning wasn't done, that would go through probate?
Yeah, I mean, it could be anything. A lot of times I see people come to me for probate because they have a house that was just titled in their name or their name and their spouse's name, and one of the spouses has passed away. That's a main reason people go through probate, but really anything, bank accounts, life insurance policies who don't have a beneficiary name, or if the beneficiary has passed away. Same with retirement accounts, investment accounts. Really, it could be anything. If something doesn't have a beneficiary named and it's titled in just the decedent's name or the person who passed away, then unfortunately it's going through probate court.
So there's multiple reasons why we do estate planning, and hopefully there's been some reasons given in the last 20 minutes that has furthered your knowledge on this topic. But one of the biggest pushbacks that people can have with estate planning is to say, well, I don't want to do the time and the pay the attorney fees to get them done in the first place. And something we always want to communicate to everyone is that there's going to be a cost one way or the other. And if you don't do proper estate planning, the cost is having your assets tied up in court for a long time in a public way. And there's still going to be attorney's costs along with that just to get it through the process. Is that accurate, Lauren?
Yeah, 100%. Probate is completely public. You can look up anything online and see how much is in the estate and who it's passing to. And there are so many fees associated. It's not just attorney's fees, it's the executor, the administrator is entitled to fees. There's fees with dealing with the real estate. There's appraisal fees. There's court fees. I mean, it's just a lot of unnecessary expense and a lot of unnecessary, time and burden.
Perfect. So one more question to direct to you before we get to our Q&A, which we already have one really good question submitted that I want to get to. But I would encourage everyone to sign up for Lauren's weekly, I believe it's a weekly email newsletter. Mm-hmm. So there's just a lot of good topics that she discusses on that on a weekly basis. And so you can sign up on that through her website. But one that she went through recently was talking about POAs for adult children. So the most common example of this is your 19-year-old goes off to college, and a lot of people don't realize that they're not the legal guardian of that person anymore. And so there's some limitations around what decisions they can and can't make. And so just talk a little bit about planning for kids that are in college or in that stage of life.
Yeah, absolutely. So like Jack said, when somebody turns 18 and goes off to college or whatever they're doing next, they are an adult in the eyes of the law. And so whether or not the parent has been making these decisions for them throughout their lifetime, once they turn 18, the parent can't make those decisions for them unless they have specific authority to do so. So if something happens when your child is in college and they get into a minor accident and they're in the hospital, unless they have a specific power of attorney for healthcare designating the parent or sibling or another loved one as their agent, the hospital doesn't have legal authority for anybody to make these decisions for them. So I always recommend that when kids go off to college or just turn 18 and leave their home, just have the basic power of attorney documents in place. Just in case something happens, you want to make sure that a parent or a loved one is able to make these decisions for you.
One other question before we jump into the Q&A here on the costing that Jack had brought up is with kind of this revolution of being able to do everything online now, an online attorney, an online financial advisor. Is it wise to prepare your documents via one of these online websites, or does it make more sense to sit in person with an attorney? And if somebody has already done online documents, what may some of those pitfalls possibly be?
Yeah, so I get this question a lot because it is so easy to go on your computer and, type up a will. But I generally would say to stay away from these online estate planning providers. And I think the only time I would be okay with this DIY solution is if you have very minimal assets, you don't own a home, you have less than $100,000 in assets collectively, and you don't have minor children. If you were just trying to name an executor who's going to manage everything, and you want to say who's going to receive everything, maybe an online will suffice for that purpose, as long as your assets, don't go above that $100,000. But in terms of the biggest mistakes that I've seen with these documents, You know, the first and biggest mistake I see is that people will go online and create a trust, which is a complicated document to begin with, but then they don't fund the trust. They don't transfer anything into the trust. And if a trust isn't funded, it's not going to work when you need it, and it's not going to keep your assets out of court. If your assets do go in the trust, you know, that is what keeps your assets out of probate court. But you know, you need specific instructions on how to do this. And even though I always sit with my clients, you know, for a lengthy period of time to go over these instructions, people always have additional questions that, you know, I'm happy to jump on the phone or answer. But if you're doing this online, you're not going to have that support, and it's very likely you're not going to fund your trust in the right way. Some other issues I've seen are that people will name executors or personal representatives that can't act in that role. So there are specific requirements for who can act as an executor under Illinois law. And if you name the wrong people, then they won't be able to act, and the judge will end up just appointing somebody of their choosing. And then the third biggest issue I've seen with these online will providers or estate planning documents is the execution of the documents. So again, there are very specific rules for who can sign the documents, how many people you need to sign the documents, and what it should say. And so if you don't witness the documents correctly, then again, they're not going to be valid, and it's as if you didn't do it at all.
Perfect. Thank you for that. So I just want to get to one of our submitted questions. That this is a really good one. It's, can you touch on the current estate tax in Illinois for couples, and is it 4 million or 8 million? And how do you avoid paying the Illinois 40% estate tax if you are above that threshold?
Okay, yeah, great question. So it's 4 million in Illinois, but you can draft your documents in a way so you can pass on $4 million to your surviving spouse, and you can do what's called a disclaimer or disclaim 4 million of that. So you can get up to $8 million if you're married without paying that estate tax, but it is $4 million, not 8. And then in terms of how to avoid paying it, you know, that goes into that what I was saying just now about the disclaimer. So first, in Illinois, it's not 40%. That's a federal level that you're paying 40%. In Illinois, it goes between like 12 to 20%. It depends on a lot of different factors. But you can avoid it or try to avoid it by doing what I just mentioned, a disclaimer, or there are some other estate planning techniques. But in general, what you're doing is you're saying, you're disclaiming or saying, I don't want this amount, and you're putting it into what's called a bypass trust or a credit shelter trust. You know, there are different terms for this, where you can still, the surviving spouse can still use those assets, but they're not counted as part of your estate for estate taxes. So you can pass on more than the 4 million to your beneficiaries, but you need to do it in the right way. You can't just, you know, avoid it without doing any estate planning. And if you, Jack, if you have any additional questions, you can feel free to email me or call me.
Awesome. So lots of great information covered here. Jack, do you want to touch on a little bit, if somebody's listening to this and they maybe feel like they don't have the proper documents in place, they're not sure if they have the proper documents in place, how we can help them, and then what some next steps would be in terms of getting in contact with Lauren or an estate planning attorney generally to make sure they do have the right documents in place?
Yeah, so the first thing I just wanted to tell everyone is that we do have a tool now where we're able to summarize your estate planning documents, anything from a POA to a healthcare directive to a will to a trust. And it provides a really good summation of what your documents say instead of reading through pages and pages of legal jargon. And oftentimes, if it's been enough time or there's been some life circumstances that have changed that Lauren has talked about in the last half hour, we'll often say you need to meet with an actual estate planning attorney to update these for whatever reason. But the good first step is to get your current documents summarized before going to that estate planning meeting with someone like Lauren, because it just helps distill down the information of where you're coming from. Obviously, if you don't have documents in place at all, there's nothing for us to summarize, and we'd say, hey, you got to make the meeting ASAP with Lauren or another attorney. in your area. And so that's the first thing I want to underline. But two, Lauren, could you just share how to get in contact with you, either for a review of an estate plan or to get a new one in place where there's no documents at this point in time?
Yeah, so the easiest way is just to email me. It's lauren@kaplanestatelaw.com. Or on my website, you can just go from my website and book an appointment if you're ready to do an initial consult. And that's kaplanestatelaw.com. Or if you're, into social media, I have an Instagram account where I like to post some helpful tips, and I post my blog and my newsletter on there as well, which is just Kaplan Estate Law.
Perfect. Thank you. Well, we appreciate everyone for attending today. We hope it was helpful. And there is going to be a survey that's going to pop up when you exit the Zoom webinar. If you have any commentary, we'd love to hear it. And if there's any other topics that you would want us to cover for future webinars, please let us know, because we want to be doing these as much as is helpful for everybody. And so we really appreciate any feedback you have to give there. So thanks all for attending, and we'll be in touch. Thanks.